Most people think a will is all they need to protect their assets, but in California, that is a mistake, and it could cost your family time, money, and even control over your estate. The truth is, trusts and wills work very differently, and if you don't understand the differences, you will leave your loved ones with a legal mess. I'm Ali Talai, an estate planning and asset protection lawyer, author of Estate Planning for Real Estate Investors, and also founder of Talai Law Offices. And in this video, I'm breaking down the three biggest differences between a trust and a will. You don't want to miss the last one because that is the most important one. Number one is when they take effect. When you write a will, there are certain formalities that you have to follow as far as having it in writing. That's always a good thing. Having it signed, having it dated. And if it's a typed will, we definitely need to make sure it's witnessed by two separate witnesses. So we're going to say all the formalities for the will and the trust have been done correctly, and that's not the issue, or there's no concern as far as that goes. A will becomes effective after the person passes away. A will does not have any legal power until the person passes away. And the reality of it is, in most cases, you actually have to have the will reviewed by the court. You need some sort of a court approval. There's more to it. But realistically, again, that doesn't happen until the person passes away. You compare that to a revocable living trust. A revocable living trust becomes effective as soon as you sign the document. As its name suggests, it's a living document. I don't have to pass away for it to become effective. So that is the number one difference between a will and a trust. Number two is incapacity planning. As we just talked about how and when a will becomes effective, it requires the person to pass away for it to become an effective document. So if the person has passed away, if it's at that time that this document becomes an effective document, you could see there's really not a whole lot of incapacity planning that we could do in a document like that. Even let's say this person has written a will, and inside of the will, he's indicated that at the time I become incapacitated, I want my spouse to be the agent. I want my spouse to have the authority to do whatever that needs to be done, or my kids, or whoever this person, let's say, for example, writes in their will to take care of issues while they're incapacitated. It really means nothing, because the will doesn't become effective until the person has passed away. So the reality of it is, in a will setting, you cannot have any incapacity planning within that document. However, you compare that to the trust, as I mentioned, that it becomes effective when you execute the trust. It's effective right there. I don't have to pass away for my trust to be an effective document. So because of that characteristic of this revocable living trust, we can have incapacity planning in there. I can have a successor trustee named in my trust, and it says, hey, upon my incapacity, and again, this is all mental incapacity, that this person will be able to serve and do things that needs to be done without any court intervention and any of those sort of things. So that's the second difference between a will and a trust, incapacity. All right, so number three is avoiding probate. When you set up a will, if that's the only thing that you've set up and that's the main estate planning documents that has been used, then in most cases, we're going to need to go to court, or our executor administrator would need to go to court to have the court review the will and realistically administer the will through the court proceeding. And as you probably seen other videos, you don't want to go to court. You don't want your kids to go to court unless you don't like your kids. Then you let them go to court. You let them go to probate court. But the reality of it is, we want to avoid probate court. Why? Because it takes a very long time. Probate cases that we do, 1.5 years is probably our average time. Probate cases are through the court system, which means they're public information. All the stuff that we have becomes public information. So somebody wants to find out, how many properties I have, who am I giving it to, where they're located, when they're getting it, all that stuff, they could access those sort of things. So there's no privacy within a probate setting. And then the cost associated with probate is usually very expensive. For example, if you have a home that is worth $1 million, which used to be a lot of money, but now in California, particularly Los Angeles, that's just like an average home. It doesn't even matter what you owe on it. If it's $1 million home, the minimum statutory fee for probate proceeding is $46,000. So for all those reasons, we try to make sure that we set up an estate plan that we could avoid probate. However, if the only thing you have said is a will, then there will be a need to go to court and have the court administer the will. You compare that now to a trust, to a revocable living trust that has been executed correctly, it's been drafted accurately, and you have also funded your trust. That's really important. You could have the best trust in the world, but if your assets, if your home still sits outside of your trust, there's still some sort of a court proceeding will be needed at the time you've passed away. So again, we want to make sure we have the right trust in place. We want to make sure we have transferred or somehow connected our assets to our trust. At that point, when we're not here, since we do like our kids, they could actually avoid probate and all that year and a half of going back and forth to the probate court could be eliminated. Not that there's nothing to do, but all the stuff that needs to be done could be done in a much shorter time. The cost associated with probate, again, could be reduced a lot. Again, not that there is no cost, it's just things could be done faster, and in most cases, what it takes to administer the trust, it would be less expensive than if it was going to be a probate proceeding. And then again, because it's we're not in the court and we are outside the court in a trust administration, then we have a lot more privacy. So this last difference between a will and a trust, which is avoiding probate, that becomes a huge difference between the two of them. And if you own real estate, if you own your business, an S corporation, an LLC, that realistically would the better plan for you would be to make sure you have a trust-based estate plan. We just dove into the 3 key differences between a California trust and a will. But did you know that the type of trust that you put your assets into can massively impact your financial future? Check out this next video where I will cover the differences between a California revocable trust and an irrevocable trust so you know which is better for you.